Your Honor, James Kazicki, I'm asking the court right now if I could withdraw on this matter. I don't think I could adequately help Mr. Lanto in his legal arguments because I'm not familiar with the issues in it. And I'm just asking the court if I can withdraw.
All right. And Mr. Lanto, a different court-appointed attorney.
Well, I just want to clarify and make sure I'm going to be able to speak for myself in the court. I don't want anybody speaking for me. As a matter of fact, I mean, all I really want is to be left alone. So that's first and foremost. And then as far as an audio only recording, I was told that there's an objection to the audio only recording. And I'd like to know, I don't feel safe without a recording. So is there any
Right from the start, you can feel how this is going to go. The lawyer steps back and the defendant steps forward, not with a defense, but with fear. Fear of the system, fear of being recorded, fear of being misunderstood. When someone says, "I just want to be left alone," inside a courtroom, that's already a red flag. Courts don't work on isolation, they work on process.
reasonable objection?
Well, first off, you can't record in the courts of law. They're already, if you'd like a transcript, everything is already being recorded by my court recorder. And I can assure you that there's no, the recording device is on and it records, and that's what she does. She records everything. So if you'd like a transcript of that after the proceedings, you're more than welcome to order a transcript. So
I've been told that before, and then when it comes to getting the transcripts, I still am waiting for the transcripts when I was told that in the past. So
well,
like I said, I don't feel safe without a report.
I know that you're not talking about the 23rd District Court, because I know if you've ordered a transcript from my court, those are always forthcoming. I've never had to deny anybody a transcript. So if that happened to you in another court, then I suggest that you call the State Bar of Michigan and report that court, because obviously they're not doing things correctly.
Well, yeah, I have no desire to do that. All I want is to have fair.
This is where reality starts clashing with suspicion. Courts are recorded, every word, but distrust doesn't respond to facts. Once someone believes the system is lying, no explanation feels safe enough. You can hear it in his voice. He doesn't want transparency, he wants control.
The police authority. That is a misdemeanor punishable by 93 days in jail and or up to $500 in fines. So, as to that charge, how do you plead? Guilty or not guilty?
Well, first, can I just make a few clarifications?
I'm going to caution you that anything you say can and will be used against you. So,
I understand.
As to guilty or not guilty, that's just the only question I'm asking right now.
Well, in order to say guilty or not guilty,
or you can stand mute, which means I'm not saying anything, and then I will enter a plea of not guilty for you, so that you don't have to say anything, and it automatically goes to not guilty. So are you pleading guilty, not guilty?
Under the cause and nature of the charges, correct?
Right, which is what I just told you. I just told you what the charge was.
Okay, and you're stating that it's based on an interaction. So my guess is that you have no firsthand knowledge of anything that happened.
Well, I'm not stating anything. All I'm telling you is what the people of the city of Taylor have charged you with. They have charged you with a violation of City Ordinance 32-31. That ordinance is commonly known as, by name, as interfering with police authority. I'm not putting any allegations. I'm not stating any facts. I'm merely stating what has happened to get this case into my courtroom. That's it.
Well, you sound awfully fair to this point, and I certainly appreciate that. Because, yeah, and just to be specific, it's not the people of the city of Taylor, it's David Jones, and then I don't know the name of the prosecutor, and I just want to make sure that the prosecutor is aware of, Section 241, Section 242, Title 18, deprivation of rights under color of law.
First off, that's a separate, what you're talking about is civil type cases.
Well, it's also criminal.
So what I'm saying is, in this matter, the matter that is before me, okay, is a misdemeanor matter where it is alleged that you violated an ordinance of the city of Taylor, the people of the city of Taylor, through their attorney, have acted to bring a case against you. So the only
This is a classic moment. The court asks one of the simplest questions in law, guilty or not guilty, and it turns into a philosophical debate. Not because the law is unclear, but because avoiding the plea feels like power. The irony is, refusing to answer doesn't stop the case. It just hands control back to the judge.
then are you guilty or not guilty? Or standing
Well-
mute? Those are the three things we got going on right now.
Well, I first have to clarify, you did say that I
I don't
was
have to force that to
presumed.
clarify anything, sir. I'm being very fair with you. And right now, you're basically splitting legal hairs. Right now, the only thing that I have jurisdiction over is doing arraignment. Nothing
Well, you
more,
seem-
nothing more can happen in this case until the arraignment happens. And the arraignment
Well,
is whether or not you plead guilty or not guilty. And if you're unresponsive to that question, then I'm gonna enter a plea of not guilty for you so that I can protect your constitutional rights. Because a lot of people don't, I enter a plea of not guilty for people who don't really know how to answer the question. So that way they're not getting, no one's gonna be bamboozled or said that, well, you said guilty and you didn't know what was going on. I don't want that to happen. I say that you're either gonna plead guilty, not guilty. If someone is unresponsive to that question, then I automatically just enter a plea of not guilty for them so that they can preserve all of their rights to a trial and everything else without having been, that's all well and good, but it's not the time and place for it. See, that's the problem is there's a time and place for everything in the matter of procedures of courts. And when you just start trying to jump the gun and go right from 0 to 60, that's not how it works. There's a stepping process and everything has to go in that process. And the process today is an arraignment. It's just.
Here's the part most people don't understand. When a judge enters a not guilty plea for you, it's not punishment, it's protection. It preserves your right to trial. The court is actually stopping you from accidentally hurting yourself.
And
Copy of my, sir, please, I have not cut you off at any point. Please don't cut me off. This is a copy of my oath of office. And why do I keep it here? Because it constantly reminds me that what am I going to do? I do solemnly swear that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office. So I take that very seriously. My son serves in the Marines. He takes his duty to uphold the line. That I am not going to uphold the Constitution, or that I am going to take an oath and not be true to my oath, then I take offense to. And so if you sense any sort of anger, there's no anger. The only thing I'm telling you is that you are implying that I somehow am an oath breaker. And I am not.
Well, I didn't. I
So,
didn't.
but
imply
that's
that.
exactly what, I swore an oath to the Constitution that I put my hand on the Bible and swore to. And I'm telling you, I don't break my oath. Nor am I going to give legal advice, because that would be more legal advice that you would talk about with your attorney. And when I'm wearing the robes, I can't give legal advice to either side. I'm more like a referee. I can throw a penalty flag, I can call a whistle for a violation of a rule that I see one side doing or the other side doing, but I can't coach either team.
Well, I certainly
So that-
appreciate you being fair. Yeah, because
So the answer to your question is I can't answer your question, because that would then be giving you legal advice. And I'm not allowed to give either side.
in this particular case, there are crimes that occurred, but the crimes that occurred were the people that put their hands on somebody that had no desire to be having somebody put their hands on them, and then binding them, and then placing them in the back of a gangmobile, and then taking them to a cage. That's the victim in this case. And the victim,
Okay,
if the victim is going to be the city of Taylor, and it's going to be presided over by a judge that is paid by the city of Taylor, with a police officer that's bringing the charges with the help of
This is where it gets personal. Accusing a judge of oath breaking isn't just a legal argument, it's an attack on identity. You can hear the shift. The judge isn't angry, but she's offended. And honestly, that reaction is human.
attorney, and then they don't know what 241 or section 241 title 18 conspiracy to violate my rights, then I have serious concerns for the fairness and the meaningfulness of these proceedings. And I think that's very reasonable.
I am a judge of the 23rd District Court of the state of Michigan. It's located in the city of Taylor, but I am not, I don't work for the city of Taylor.
But you see do you see my concern for my safety?
I absolutely, except for the fact is I'm presiding over the whole case, and I'm going to make sure everybody has due process. Everybody has the same fairness. to bring their case and to make sure that they can cross-examine witnesses and make sure everything is recorded by my recorder, who also has sworn an oath, and I find her to have never have broken her oath either. And so I'm just telling you, I'm going to be doing my job, and my job is to defend the con. It was set for arraignment. I have entered a not guilty as to the charges against you. And right now I can do one of two things. One, I can set this up for a pretrial. The pretrial is something that I always afford the parties, where they can talk to one another. If they want to work something out, I have no problem with the constitutional right to enter into contracts and to do things like that. Or I can just set it for jury trial or bench trial right now. If you want to forego any of that and say, look, I really have nothing to discuss with them, I'll just like to go to trial. So would you like to meet with the prosecutor? Well, in which case I will set this up for a settlement conference date where the two of you can discuss the matter. Or I can just set this for a jury trial or bench trial right now.
Well, I mean, I do have a couple objections to that, because I'm being labeled and called the defendant here. And what I'd like to be called is the victim. And what I'd like to do is, if this is a fair proceeding, then that prosecutor, as long as we're going around and throwing out suspicions and alleging crimes, I'm going to allege them of the crime of the Department of Justice, Section 241, 242, Title 18, which is deprivation of rights under color of law. And I take serious issue with people acting like criminals.
Calling yourself the victim while you're the charged party doesn't flip reality. Federal statutes don't magically erase local charges. Our courts have lanes, and every time he jumps lanes, the case stalls instead of moves forward.
Well, I'm willing to forego any intention of criminal charges against the prosecutor if they're willing to just dismiss this now and leave me alone.
So here's the thing: is I'm going to give everybody the opportunity to look at the case and think about it, and not have to. I made sure that you didn't have to take a guilty plea right off the cuff without having to think about it. So I'll set this for a settlement conference. Settlement conference, and everyone can come back at that settlement conference. And if there's if there's a resolution, then there's a resolution. If there's not a resolution, then I'll ask if you want a bench trial or jury trial, because that's your constitutional right, and I just need it.
Because I'd like to talk to this prosecutor who I suspect is a criminal at this time, and I would like to.
First off, I'm going to caution you, Mr. Lanto. I'm going to caution you, and I'm going to caution you once. And the next time it happens, I will hold you in contempt, because I will hold anybody in contempt. I do not run a Jerry Springer show. I do not run a Jerry Springer show where the litigants are going to use words and things and call each other names. If you're going to refer, I'm not referring to you as a defendant. I rightfully could. Anybody who has charges brought against them is for a moment known as a defendant. If you look at a dictionary and look up defendant, that's what it says. But you prefer not to be called a defendant, and I acknowledge that, and I'm going to call you Mr. Lanto. You are not.
Oh, sure. Thank you.
You are not, and I repeat, not until you prove otherwise in a court of law beyond a reasonable doubt.
Sure. Well, I've been alleged to be a criminal.
I will make sure that the proper respect is given to you. I'm going to ask the same of you. So you will refer to Mr. Greco as either Mr. Greco or as the prosecutor, but you're not going to call any other litigant or any other witness or anybody else a criminal unless they actually have a criminal record or they have been proven to be a criminal in a court of law by a jury of their peers.
Yeah, and for the record, I called him a suspected criminal. Well, I'm very careful. I'm very careful with my words.
Again, you're splitting hairs, and I'm just telling you right now. I'm giving you one heads up that I don't allow any kind of Jerry type Jerry Springer stuff where there's going to be finger pointing, chair throwing, and name calling.
Well, I did do a cop watch karaoke, which is probably what led up. Which is probably what led up to this.
All right, so I'm going to set this for a settlement conference. All of your contact information is correct, so I can make sure that due process is afforded under the Constitution, and I'm mailing notices out to the proper spot, and that's the Cloverdale address.
No, and at this time I don't feel safe giving an address, but I'll give you a phone number and email address that I can be contacted by, because I do want to participate in the settlement conference.
Well, right, but I also need to. I'm required by law to mail it out to your last known address. So if this address is something that you will still receive, all I'm saying is I already have an address. I don't.
Yeah,
I'm
no,
just saying, is it still current? Is it still
in the
current?
activism that I do, it's important to stay on the move because I have people that try to retaliate against me and do violent things to me. So I prefer
All right,
not
well,
to.
then that's up to you. That's up to you to go to the, it is incumbent upon you to go to the post office and make sure that they have your forwarding address. I'm gonna mail, my clerk is gonna mail it out to the Cloverdale address. And if you didn't put a forwarding on there, well, that's between you and the post office. We
Well,
don't
if there's
send out
also
emails. We don't send out emails as notice, but, and we don't make phone calls about, to let people know when the notice is. We use the mail system because that's the only thing that's tangible and can actually be proven. Why? Because you can see that you put something in the mail, you can actually see that it's been in the mail because it's posted. So.
yeah, is it going to be certified? Because that's the only way really to prove that somebody got it.
No, it's not.
The Jerry Springer warning isn't about insults, it's about control. Courts aren't theaters. Once accusations start flying, authority has to draw a line fast.
We don't have to send it by certified mail under the court rule. And the court rule has already been ruled to be part of the Constitution, and it's already been ruled as being constitutionally proper under due process of the Constitution. So I'm going to mail it to your last known address. If you have some sort of change of address, that's between you and the Postal Service. All right. So we're going to set
Well,
this
yeah,
for a
'cause it-
separate conference date. It'll be sometime in the new year, sometime in January, and we'll see everybody.
Okay, I certainly appreciate you being fair.
That's what I swore to do. That's what I always do. Have a good day.
Thank you.
Now, Mr. Gazicki, if I didn't make a ruling on your request, it is granted. So now I have Idoni.
And in the end, notice what wins. Not volume, not theories, not accusations. Structure wins, calm wins. The case moves forward, not because the system is cruel, but because it refuses to collapse into chaos.